cases. So now we don't normally cover employment tribunal level cases because, of course, they are at the lowest level of the hierarchy of the court, and so we only tend to report on the Employment Appeal Tribunal and upwards. But this is an interesting one. This is an employment tribunal level case, and it is also, interestingly, one of the first coronavirus cases that we have come across. And this is an important one because it brings up the opportunity really for us to have a chat about interim relief. And I don't know to what extent any of you will have come across interim relief. It isn't common at all, but it is quite a drastic way that not a drastic way that a claim can be brought, but it can have some quite drastic consequences. So first of all, let me just explain. So what is interim relief? So interim relief is where an employee believes that they have been unfairly dismissed for a reason that is connected to whistleblowing, trade union membership, or because of their activities as an employee representative. So this has come about, particularly in this instance, in this case, it's come about because of complaints that were made about personal protective equipment, health and safety in relation to the coronavirus. So that was the whistleblowing aspect of it. And there was also a trade union membership aspect to this case as well. But it doesn't have to be more than one. It can just simply be complaints, for example, complaints about health and safety in relation to coronavirus, which I'm sure many of you will have come across. So that would potentially be someone blowing the whistle. And then if they are then dismissed because of that, then clearly they've got an unfair dismissal claim to argue, but also they've got this option of putting in an application for interim relief. So that's when you can do it. What it actually means is that somebody can, or I say somebody, the ex-employee who is dismissed can put a claim into the tribunal, but they've got to do so within 7 days of their dismissal. So they've got to be really quick off the mark. And in reality, the only people who are quick off the mark and are aware of this tend to be those who have either been receiving legal advice before the dismissal, or alternatively are members of the trade union. And so therefore have been getting advice in that format. Most people aren't aware necessarily of this sort of claim, or at least not able to bring it in such time, because usually the appeal process is still going on at this point, because you've usually got the 5-day limit, 5 working day limit in relation to the to lodging the appeal that most employers have. And so by the time you've exhausted the appeal process, this 7-day time limit has been and gone. Okay, so you've got to be really quick off the mark. Claimant's got to be really quick off the mark. But then what they do is they put in this interim relief claim. The tribunal will then hold an emergency hearing. So usually the hearing is held within a week or two of the receipt of the application. There isn't specifically a requirement to put in a response by the employer at that point. But then essentially there is this emergency hearing, and what the tribunal is then deciding to do is whether to reinstate the employee. Subject to the for example, a hearing at the employment tribunal within the next couple of weeks. And if the tribunal then agreed with me, that when I say agreed with me, that's when we move to these next couple of bullet points. If they think that my case looks like a winner, that is quite an amusing legal test that's been set out in this case. So it's not on the balance of probabilities or anything like that. It's if the case looks like a winner. But if my case looks like a winner, so they think that it's very likely that I'm going to succeed with my claim at the actual final hearing when that takes place, then I get reinstated. And I get reinstated into my role on my full pay until the full hearing is then heard. So it doesn't necessarily reverse the dismissal, but it means I'm getting my full pay in the meantime. So it is a hugely onerous outcome for the employer if the employee is successful. Now, they're quite challenging because, as you can see, it's only in instances where the case looks like a winner and it's the burden of proof is on the claimant. So, I mean, these cases are really quite rare. I have done a couple of these hearings, and in both instances, we, and when I say we, the employer, successfully defended it, so there was no reinstatement. And so we then just sort of rolled on to the main hearing at a later point. But you need to be aware, because if one of these lands on your desk, then it really is a case of all hands on deck to deal with it. Now, just to give you the actual facts, so again, putting it into the context of a real situation. So as I said, this was a COVID-19 case. So this was in instances where the employer was requiring a 25% decrease, a cut in pay for all its employees. Now, Mr. Morales, he then sought advice from his trade union, and that wasn't very well received by the employer, shall we say. So what we are looking at here in terms of how that wasn't very well received, we had evidence of the fact that various comments were made by the company's management, and these were recorded comments, audio recordings of comments. So one particular person in the firm has decided to go to a union. That person is obviously not back in the company. I'm extremely upset and disappointed over this one person who has decided to go to the union. Disgusting. If they are not careful, they will ruin this company. So you can see from this comments that the employer was very unhappy, and this is pre-dismissal, was very unhappy that this individual had gone to seek a back and got the trade union involved. He'd also complained about the lack of PPE, which they made an issue well, and then he then raised a grievance and then agreed to the pay cut. So those are the circumstances. So then the tribunal, in considering this application for interim relief, so considering whether this case looked like a winner or not, they concluded that it was, and so he was then reinstated pending the full hearing. Of course, the other thing that we've got to bear in mind in terms of the impact of this is that there can be some significant time delays in hearings actually in cases getting to a full hearing at the moment, although it does appear to be a little bit inconsistent across regions. I've got a client where a couple of weeks ago we had a case listed for the end of December, which is only a couple of months away, or 3 months away. So in some instances they are being able to turn these cases around quite quickly, but in other instances we're looking at 18-month delays. So it sort of depends upon the size of the case. Equal pay. So we have an equal pay, quite an important equal pay case, and certainly slightly employer friendly, this one, I should say. So this is a case which deals with the issue of the material factor. So where you have differences in pay between a man and a woman for doing equal work or similar work of equal value, I should say, then you can pay people differently if you can show that the difference is because of a material factor. And that factor need only be material in what they call a causative sense rather than justifiable. Sorry, I have difficulty saying that word. Rather than justifiable. So the reason or explanation that the employer gives doesn't necessarily need to be a good one. And this goes back to some older case law, the Marshall case, which I've highlighted below, where in Marshall there was a historic explanation for the disparity in pay, because there had been different collective bargaining arrangements for the two groups of employees, which had caused the difference of pay. Didn't necessarily justify the difference of pay, but it had caused it, and that causation had nothing to do with sex. It wasn't sex tainted in any way, shape or form. So when we have a look at this case involving Mrs. Walker. So Mrs. Walker, so she was in the role of Chief Human Resources Officer, and in 2014 the cooperative group were in a financial crisis at that time, and so Mrs. Walker and the rest of the executive were considered essential to the company's survival. They were all offered an increase in pay, although Mrs. Walker's salary was lower than that of other members of the group. The crisis was survived, but then Mrs. Walker's role was then downsized, including a reduction in salary. And then in February 2015, notwithstanding that, we've then got a job evaluation that showed that Mrs. Walker's role was comparable to other people who were paid more. So we've got to clearly, on the face of it, there is a disparity in pay, and so therefore it's a question as to whether it's tainted by sex or not. Now, the justification, or should I say the reasons why they had come to the conclusions of paying Mrs. Walker differently, was because she was newly promoted into that role, so she was unproven at executive level. Her flight risk, so her importance to the business, although it was described that the importance of all the executive at the point of crisis was the reason why those pay increases were given at that time, but her flight risk and her importance was less than it was for others within the executive. And so therefore we had the material factor that was therefore being justified at that point. But what the Employment Tribunal initially said, and I'll move on to what the Employment Appeal Tribunal said in a moment, because it is different. But I see the logic here that what the Employment Tribunal was saying, because they are saying that sometime between February 2014 and February 2015, when the job evaluation scheme was effective, the tribunal ruled that the material factor could no longer stand. And that has got a certain degree of logic to it. Sorry, I'll just get back aside. But what the Employment Appeal Tribunal said was that wasn't the case. There was no evidence to show that the material factor, whilst it might appear, reading between the lines, that perhaps the influence of the material factor might have declined, there was nothing to show that the material factor still didn't exist at that time, notwithstanding the job evaluation scheme being introduced and the output of that job evaluation scheme. So essentially what the Employment Tribunal concluded was that there was still a difference in pay, but that difference in pay wasn't tainted by sex, and that those that were paid more were still being paid more for the reasons that were set out before, in that they still had greater experience at an executive level. They still had a higher flight risk, and so therefore the material factor still existed, and therefore it was still an appropriate material factor defence to be able to run. Now, just sort of cutting through that somewhat, the impact of this decision is to reaffirm the decision of the Marshall case, which is really that it's going to be potentially easier for employers to rely on material factor defences as long as, and only as long as, those material factors are actually clearly got nothing to do with sex. They're not tainted with sex in any way. And obviously that's then when you do get all of these arguments, you'll be, and I'll mention it a little bit later when we get to talk about the cases that we're awaiting decisions for. There's a huge, as the equal pay case that is going through the courts at the moment. And of course there's a huge emphasis on, or there is a material factor issue that will be being discussed in that case. But that's where you've got two groups of employees, one working in the shop, one working in the warehouse, the men working mainly in the warehouse, the women working mainly in the shop, and the difference in pay therefore is going to be tainted by sex. In that instance, it would appear. I mean, obviously we'll have to wait and see what the outcome of that is, but essentially when we're looking at equal pay cases, one of the key defences that we've got is material factor. So we need to ensure that we're on the ball in terms of why people are paid less, and particularly where you get complaints about equal pay, where you get grievances about equal pay. It's about having a look at the real fundamental reasons as to why those differences are there. Now, this case, Gallagher case, this is just a really quite interesting case where can a dismissal be fair in the absence of any process at all? So this is the whole, the whole code of practice, and making people aware of the fact that they may be at risk of dismissal and the right to be accompanied at the meeting, and so on and so forth. And this was a case where there was a complete and utter breakdown in the working relationship between the employee, this customer service manager, and her manager. And essentially what happened in this case was that she was then brought in for her employment appraisal, her annual appraisal, and she was then simply being told she was being exited from the business due to a lack of trust. There had been at least 2 previous meetings to consider the difficulties in the relationship, but the employer had concluded that it was now, the relationship was irretrievable. And so therefore, they were then dismissed for some other substantial reason because of this breakdown of essentially the, not trust and confidence as such, but just the breakdown in the working relationship between the two. Now, the Employment Appeal Tribunal ruled that where following procedures could reasonably be considered to be futile, the employer may dispense with them, and this was a rare example of such a case. So I'd just like to emphasise that last sentence. This is a rare example. So this isn't necessarily that we should be jumping on this in particular instances to be dismissing people without a proper process, because that is really quite risky indeed, but it can be done very carefully. And as I've said that here in this final bullet point, it's because what we're doing here is we're dismissing for some other substantial reason. So it's not a conduct dismissal, it's not a performance dismissal, it's not a capability dismissal, a long-term absence or a short-term absence dismissal. And so actually technically the ACAS Code of Practice doesn't apply. And of course it's the ACAS Code of Practice which tribunals will take into account when concluding whether a fair process has been followed or not. But you've really got to have some very, very strong evidence to show that following a process would be futile. They did have that evidence in this case, but all I would say is, interesting, tread carefully. We could perhaps have a think about it in some instances. So give me a call if you want to discuss anything like this, but we would have to be incredibly careful indeed and be very and fully aware of the risks of doing so. Vanishing dismissals. So this is a rather interesting instance. So, this case, the Phoenix Academy case, isn't really anything. It's reaffirming the decisions that we've already seen before in cases like the Leeds Teaching Hospital case and the Folkestone Nursing Home case, which is that if you are dismissed, or if an employee is dismissed and they appeal, and then at the appeal you decide to reinstate them because the original decision was wrong, then the dismissal vanishes. In law, they have actually not been dismissed, so they can't refuse to be reinstated if they have raised their internal appeal, because it naturally follows that if you are appealing against the decision, that ultimately you believe the decision was wrong, you want it overturned. And so a lot of, now obviously this doesn't happen very often, because most of the time where an employer has dismissed, they're usually quite comfortable with the fact that they've decided to dismiss. And usually an employee will see the fact that they are appealing as jumping through the hoops as required, because they've probably been told by ACAS, advised by ACAS, that they should appeal and that they need to do so before they can issue their claim. Well, firstly, employees don't have to appeal before they bring an employment tribunal claim. Yes, if they don't do so, it gives the employer the argument that they haven't followed the ACAS Code of Practice, and we can ask for a reduction in compensation. But there isn't a bar on them bringing their claim because they haven't appealed. Also, if they do appeal, then from an employer's point of view, it gives us the great opportunity to actually then begin to understand what their complaint is about the way they have been dismissed, or the rationale behind the decision to dismiss, and it allows us to correct all of that. And there's an OCS, a case called OCS versus Taylor, that deals with that appeal rectifying failures, potentially rectifying failures of an earlier disciplinary hearing. So it allows us to strengthen our case. And also, ultimately, of course, if we've made the wrong decision, it allows us to reinstate. So it's an interesting concept, and it's an interesting thing to consider from a tactical point of view if ever you are placed in that situation. Because, like I said, from a legal point of view, it just simply means that that the decision to dismiss vanishes.